Going. Thank you so much for joining us, everyone. Really appreciate it. I think this is the 10th session for our Insight into Games month here at Yuki, which is fantastic. Delighted to be joined by Paul and Richard from Taylor Wessing, here to talk to us all today about investment. And I suppose take it away, guys. Over to you.
Thank you very much, Leo. Good afternoon, everyone. Thank you so much for joining us today. We hope you'll find this session useful. We've designed this specifically for gaming businesses looking to raise money and take investment from early stage venture capital funds and/or corporate venture investors such as big tech or big publishers. Venture capital investing across the entire technology space, but particularly within gaming, is an area where Taylor Wessing as a firm and myself and Paul especially do have quite a lot of experience. And as you're all likely aware, while there has been a relative decline in financial investors allocating funds to pure gaming content businesses over the last year or two, there are still a lot of deals being made for strong businesses in the sector, especially those building tools or platforms to support the industry, the so-called picks and shovels businesses. And we have seen increased activity from corporate venturing, where large strategics and publishers are acquiring minority stakes in early stage gaming businesses, often with a view to future acquisitions. So this is still very much an active area, and we thought therefore it would be helpful to discuss this topic. The session today will hopefully provide insights into the latest market terms and guidance on how to get your legal house in order, as it were, in preparation for an investment. But before we jump into that, perhaps just a brief introduction to myself and Paul and our firm Taylor Wessing. So my name is Richard Fakeney. I'm a partner in the corporate team at Taylor Wessing, and I've been advising clients on strategic M&A and venture capital transactions for over 12 years now. I'm focused on supporting innovative businesses and founders within the technology space, generally ranging from startups and venture capital funds all the way through to big tech investors. I have a particularly strong focus on supporting the video game industry alongside other fast-moving areas such as fintech, AI, and digital infrastructure. And I'm joined today by my partner, Paul. Paul, please do introduce yourself.
Yeah, hi everyone. Thanks, Richard. My name's Paul Thorpe. I'm also a corporate partner at Taylor Wessing. My practice tends to involve advising early to mid-stage companies on fundraising rounds, and then we guide them all the way through to a point of exit sale. So I'm admitted to the bar in California, as well as qualified in England and Wales. So a lot of the work that I do tends to have a US focus or US angle to it. So largely around US investors coming into UK and European companies, or advising those European companies on point of sale exit processes to US buyers.
Thanks, Paul. So who is Taylor Wessing? Well, we're a global law firm focused on supporting the most innovative businesses and founders across the full range of technology, life science, and media sectors. We're actually one of the UK and Europe's leading tech firms. We've spent the last 30 years advising high-growth companies and global tech leaders. We're also the preeminent UK and European law firm for venture capital investment. We advise countless companies and investors across the full value spectrum, from early stage through to late stage and ultimately on to growth financings and exits. Over the last year, we've advised over 1,000 on over 1,000 corporate VC and M&A transactions across Europe, so fairly experienced in venture capital. And as you can see from the slide there, we're pretty global. We have 1,200 lawyers across 17 countries globally, including Europe, Asia, and the US. Our direct offices are marked in green there on that little graphic. And we also have a strong alliance with leading Spanish and Latin American firm Ethoha, which extends our coverage into that region. So that's kind of a snapshot on Taylor Wessing and our footprint. And looking at the video games industry specifically, this is a core sector for us, and one where the firm and myself and Paul especially have a lot of experience. The video game practice at Taylor Wessing is pretty market leading and fairly unique. We offer a kind of truly international and cross-practice team with a long history of supporting clients in the industry. And we advise across the entire space. So developers, publishers, platforms, private equity and venture capital investors, big strategics, but also management teams and founders through that early stage practice that we have. We act for many of the leading names in the industry, and we cover the full range of legal services. So we're really just as comfortable advising a founder team on a 5 million seed fundraising as we are a major international publisher on a $500 million M&A deal. So that's kind of the gaming practice that we have here at Taylor Wessing. And just a snapshot here on the types of clients that we typically support. As you can see, covers the full range of the industry players, international majors like Tencent, Epic, and Roblox, through to those early stage founder-led businesses, the likes of Less More, Beat Games, Thunder. And we also do a lot of work with venture capital funds. So we got Bitcraft and One Up Ventures that we work with closely. So we understand that investor perspective too, and can give you that insight from their perspective on fundraising deals and their terms. And just briefly, Leo, you very kindly already mentioned TWP. We've pulled together our expertise across all practice areas and our international offices to really put together this guide that is our kind of definitive statement on the law as it applies to the video gaming industry. We call it TW Play. We've been publishing it for many years now. I think I believe it's in its 5th edition. You can access it using the QR code or many of the links that have been shared. And it's completely free. It hopefully provides a pretty decent overview of the types of issues that gaming businesses, particularly in the early stage, are likely to be grappling with, whether that's M&A and fundraising, the types of stuff we're talking about today, but also publishing, commercial terms, the myriad regulations that tech businesses are dealing with, more AI, crypto, all that kind of stuff. So please do feel free to take a look. And if you have any further questions, by all means, please do reach out to myself and Paul. We're happy to help. But that's kind of enough on us. Let's dive into today's session. Brief overview of the kind of issues we want to cover and how we propose structuring the session today. So we're basically going to break this into 2 parts. The first part, we want to look at addressing some of the most important pre-investment issues that you want to make sure you're addressing before you get into negotiating deal terms. These can often cause some of the biggest headaches in our experience if they're not done right. The biggest issues that we tend to see are often around who owns the key assets that are important to the business, and typically that involves intellectual property and the company itself, so shares and options. And then once we've gone through those kind of pre-investment issues, we wanted to move on to taking you through a term sheet and looking at the kind of core investment terms that you're likely to encounter when you receive a term sheet from an investor, and really describe in high-level terms how those work and provide some insights from our experience on market practice. So that's the approach for today. First topic being intellectual property, and in particular that focus on how you can make yourself investor ready as an early stage business, particularly in the games industry. So the intellectual property is arguably the most important asset for any gaming business, and it is something investors are very focused on, particularly with early stage investments. They will want to know that the corporate entity that they're investing in owns all the IP that is crucial to the business. So there are a number of points to be mindful of here. So the customary position is that intellectual property, for example, copyright, will vest in the person who creates the work. For some intellectual property, like trademarks and patents, there are traditional registration steps, but as a general rule, this is the case. So this can create a tension with the idea that the company should own all the IP, since it will be the founders and employees and consultants who created it. So how is that generally addressed? Well, from a founder perspective, typically investors will expect the founders to enter into a couple of specific agreements with the company, being service agreement and an IP assignment. So the service agreement will provide all the terms and conditions of the founder's employment with the company, but it will also expressly state that any IP the founder team has created during the course of their employment will belong with the company, so vest in the company. And this is the standard customer position for all employees in the UK. And then the IP assignment will then make sure to transfer any historic IP that the founder will have created before the company was set up or before he signed his service agreement, that all that IP will also be transferred into the corporate entity that is taking the investment. And then for employees and consultants, similar position. The investors will want to make sure that all the employees are signed up to service agreements that transfer the IP and have entered into IP assignments if they haven't. point of nuance here is that for an employee in the UK, the typical position is that as a matter of law, the IP vests in the company anyway, but you do want your employment agreements to expressly say that as a general housekeeping matter. Position is slightly different for consultants, where that's not the automatic case, so you will want to make sure that any consultancy agreements are expressed on this point. And then, look, the overseas position is one to be aware of, because it's not necessarily the case that there's an automatic assignment of IP to the employer in all jurisdictions, particularly if you're employing someone through, employer of record type situations, like remote deal, that kind of thing. So you will just want to be clear on the contractual arrangements you have, both with employees overseas and your employer of record, just to make sure the IP chain of ownership is clear. And these are issues that I have seen become really live when you come to take an investment or even selling your company. They can be pretty material points that happen many years after the fact. So it's worth getting right at the outset. I think the other point I want to talk about here is around third-party this bundle of issues here that I've kind of lumped into one that you could do whole presentations on. So we don't have enough time for that today. But the main point here is around use of third-party content, whether it's open source, public images, or how you use AI in the business. I think the core message here is that investors will be keen to understand what IP is used in the business and where is it owned. Is it owned by the company? Is it someone else's IP? And on what basis are you using that? Is it on a commercial IP license? Will there be fees and terms and conditions? Are you using public images, which are generally free to use? Or are you infringing on other third parties' IP? Open source is an interesting issue. They're generally free and available to use, but any improvements you make or alterations will typically then, under the terms of the open source license, will generally be available to everyone, which can often become a problem if you're integrating your own proprietary IP into the open source. So this is an area that you want to be mindful of. I think the point around Gen AI, I think hopefully everyone on this call already will be aware of the intricacies and issues around deploying generative AI in your business and the challenges that can represent, both from an IP ownership on the output and the potential IP infringement issues on the inputs. That is definitely a whole session in itself, and not one that we have time for, unfortunately, to dive into today. Although happy to catch up, Leo, on a subsequent session if that would be of interest. I think suffice to say at this point is that a lot of caution at this stage needs to be used when deploying AI, generative AI in your business. It's definitely something that can be deployed, but it needs to be used carefully and with advice and subject to detailed operating procedures to understand where the risks are in using that. And happy to catch up with people offline around the issues there, but definitely one to proceed with caution. This covers the broad issues I want to talk about on IP. And there'll be time for questions at the end, so please do jump in later if you have any questions on these areas. Moving on, here we are. So in addition to IP, another area that is going to be really important for investors at the early stages around corporate ownership of the business. Essentially, who owns the shares and the options in the company? Who are the investors getting into a partnership with? So some key issues here. Look at the very early stages of startup companies. We typically see companies being owned by the founders, potentially with some early stage investors. You'll want to be very clear on who holds the shares in the company and ensure that your share register is fully up to date and that any shares have been validly issued. Ask yourself right now, who currently manages my company books and share registers? Is it a professional, a third party? Am I doing it myself? Can I access my registers easily if I need to, or do I know that they're up to date? If you don't know the answers to those questions, you probably want to have a think about that. And then the other issue around, promised shares and options. Have you promised anyone any shares or options in the business, but not actually formally papered that at present? Note that merely promising someone shares and options in your business is not enough to actually grant them. So they won't necessarily show up on your cap table when you're talking to investors. But having made such a promise, it can, in certain circumstances, be legally binding. So there is a risk that there is a gap and your registers are not accurate. Now, investors are going to be very aligned to this. They want to know who currently owns the business when they're investing. It's going to be important to knowing what their percentage stake is going to be. And all of this really does need to be sorted out before you take an investment. And it really is important to get the stuff right early, because it can be quite challenging to fix later down the road, after you've taken an investment, or even after you've gotten a term sheet from an investor that's put a valuation on your business. That can create a number of tax problems to try and solve if you promised someone shares and options but haven't actually given them to them yet, and then you're having to do that after you've got a valuation. So point to bear in mind, you want to be on top of the stuff early. And then moving beyond the straight share piece and thinking about options, do you have an employee share option scheme in place to incentivize employees? And do you know whether that's an EMI qualifying share option scheme or not? EMI, I'm sure a number of you will be familiar with this, but for those who aren't, EMI means Enterprise Management Incentives. And it's a type of option scheme designed for early stage companies that provides really favorable tax treatment for the option holder and the company. And it's a government policy designed to support and drive early stage innovation. But there's tax benefits both for the employees, but also for your company, and they can be really significant. So definitely worth something exploring. We recommend you explore it if you don't currently have an EMI option scheme in place and you're considering incentives. Now, Paul and I are not tax experts, but we do have a fantastic tax incentives team that we can put you in touch with if you do want to dive into these issues in more detail. But for now, just a quick overview on some of the tax benefits with getting an EMI scheme in place and why we recommend them. There's no income tax or national insurance payable by either company or option holder on the grant or exercise of the option, provided it's granted at actual market value. Now, what is actual market value? Well, this is the market value on the shares, which is typically agreed, or does need to be agreed between you and the HMRC through a formal valuation process. Sounds like a big deal, but it's generally pretty straightforward. And it's usually possible to get a pretty low valuation, especially if you have investors coming in with higher ranking shares, which means you can get options into the hands of employees quite efficiently. And there are also tax benefits around the exit and sale of the shares, right? So if you have an EMI qualifying option and it stays tax favored throughout the life, when it comes to exercise and sell those shares, the option holder would be getting capital gains rather than income tax, which is still a significant gap. And it's also possible to potentially even get more favorable capital gains tax rates if you can qualify for business asset disposal. So don't want this to be a tax lecture. I don't think anyone will thank me for that, but there are a number of real significant benefits here in getting the EMI piece right. And we would encourage people to really consider them. It is a complex regime, so you do need to get proper advice when setting up. One of the most common things we see with early stage companies when they come to us is EMI schemes which have not quite worked out, and we're having to then backfill and try and solve those later, which I'm sure Paul would agree can be a bit of a nightmare. So this is EMI. Just one last thing on EMI. I think the quick point here is that in addition to trying to satisfy all the conditions that you need to qualify for EMI options, there's then also ongoing reporting and compliance requirements that need to be followed. Now, these tend not to be too onerous, and they're usually very manageable in practice. However, we do see clients neglecting to follow these, which can be risky. If there are material failures in compliance, then that can risk the favorable tax treatment. So just something to bear in mind around these ongoing reporting and filing requirements. So that was a brisk run through the kind of key issues that you need to think about before you even get to a term sheet stage. Is my IP situation all squared away? Are all my employees and my founders signed up to sign my IP into the company? When I'm working with employer of record and overseas employees, have they signed up to the right documentation? What am I using in terms of third-party IP in the business and Gen AI? And then is my cap table and my option scheme all set up in a proper way? So these are the biggest issues that we see in diligence and causing problems when you get to a term sheet with an investor. So definitely worth considering. And with that, I think I'm going to hand over to Paul now. He's going to take you through some of the key issues that you'll likely encounter when you get to that term sheet stage with an investor who's looking to invest in your business and take you to that next stage. Paul, handing over to you.
Thanks, Richard. So term sheets. So the key factor really when thinking about term sheets is understanding where the main drivers of value lie. You could probably spend your life negotiating a term sheet, but if you're negotiating the wrong provisions or you're pushing on a closed door because they're just provisions that are not normally negotiated with investors, then you're effectively wasting time, and you're probably just frustrating people as part of the process. So it's really important that we drill down on where are the key drivers of value and what are the bits of the term sheet that can actually be negotiated in practice. Before we get into all of that, I should say that for today's purposes, we're talking about this from a UK perspective. So typically when investors come into a company, a UK company, then they'll use a form of document called BVCA standard, which stands for the British Venture Capital Association standard documents. And the reason for that is that they're a set of standardized documents, and it's supposed to make the entire investment process much smoother and quicker than it would be than if every investor had a different set of documents and you had to renegotiate them from scratch each time. But there's the British Venture Capital Association documents, but there's an equivalent set of North American Venture Capital Association documents as well. The bits that you negotiate on the two sets of documents differ slightly. They are quite similar to each other. There's been a convergence of both sets of documents over the years, but there are different points on each. We cover both of them frequently, and we act for a lot of US investors into UK companies and UK companies on US investment rounds. But given the time available today, we're just going to talk about this from a UK perspective. So we'll be focusing on the BVCA documents. But if the North American documents are relevant to you, then feel free to drop us a line afterwards, and we can see if we can help on that too. So back to term sheets. So I think one of the key points for me, at least when it comes to term sheet stage, is the focus on valuation, and at times a potentially unhealthy focus on valuation for some companies. Valuation is important, but sometimes when people try to increase valuation, it goes to vanity rather than to practical application for the company. One of the issues with driving valuation is that investors expect to get a certain level of return on the amount that they've invested. So if you push the valuation level up too high, then an investor will expect to get a return on their investment at that level. That then becomes an issue later down the line if you're looking to sell the company or raise further capital, because unless you're going to do a down round, or unless you're looking to sell at a lower valuation, you've effectively set a rod for your own back. You then have to exceed expectations and go beyond that valuation. And that's not impossible. It's doable, but it should be viewed in the context that most point of exit transactions in the UK market are somewhere between the 50 to 200 million mark. That's the average point of exit sale in the UK market for a successful company. So if you're pushing your valuation up beyond that, then just be aware that you set a bit of a hill for yourself to climb, and that might be doable, but just be aware of that. In terms of how valuation then plays out in the term sheet itself, you then start looking at share classes and how the equity ownership company is shared between investors and the founding management team and ordinary shareholders themselves. So just to kind of decrypt a bit of the terminology here, ordinary shareholders are what people would commonly regard to as shares in a company. So most companies, when they're incorporated, will have an ordinary share capital. They're shares which carry full voting rights. They're shares which carry a right to a dividend, and they'll share in the proceeds upon a share sale. So if there are 10 shares in the company, you sell the company for £10. Each share gets £1 in terms of profit at the end of the process. You then have a separate class of shares called the preference shares, also known as A ordinary shares. And that's typically the class of shares which investors in the company will be given. And how A ordinary shares or preference shares differ from ordinary shares is that they rank higher in what's called the liquidation waterfall, or the liquidation stack. So typically, if I have a company which has 10 on its balance sheet, because you've got 10 ordinary shares in issue, and I'm an investor coming in and I give you an additional 5, then I will say, here's an additional 5, but I want preference shares to cover that 5, so I'll get 5 preference shares. And then if there's a sale of the company, typically I want the option of either participating, so 5 out of 15, or I want the option of getting my money back at the end of that process. And this is where we come up with the concept of a 1x liquidation preference. So if the company is sold for 5, so it's sold at a massive undervalue to the 15 shares in issue, as the investor, I say, well, I want my 5 back, and I rank higher than you in the waterfall, and so I'll take my 5 back. And unfortunately, everyone else loses out. The other 10 ordinary shares don't get paid out in that circumstance. If, however, I'm selling the company for 20, then the investor has the option of taking their 5, or they can participate within that 15 to get the share of the 20. So in that circumstance, they wouldn't take their 5. They would just take a 1/3 share, so 5 out of 15 of the 20 for which the company is being sold. So this is the concept of the preference stack, and this is customary within term sheets. What crept in a couple of years ago was the idea of a participating preference, which means that the investors get their money back, and then on top of that, they also participate in the sale proceeds. That isn't market practice. You occasionally see it in term sheets nowadays, but if you do see that, it's usually because the company being invested in is encountering some kind of difficulty, or the investors are trying to exert terms over that company. So it's not typical for an investee company to accept a participating preference from an investor. So moving on to the next slide, we'll talk briefly about EIS and SEIS. So as Richard says, neither he nor I are tax lawyers, but EIS and SEIS are incredibly important from a UK investment perspective. What it allows is for UK tax resident investors to invest in the company and get certain tax reliefs from the UK government. Now, this isn't open to anyone who is an employee of the company. So if you're a founder, shareholder of a company, and also therefore an employee of the company because you're working day to day in the company, then you're not eligible for EIS. So you can't benefit from this relief. But if you're an angel investor, if you're an individual, you're not employed by the company, but you're putting money into the company, then you are potentially eligible for EIS. The way EIS works is that the company issues a separate class of share, which ranks more or less on par with the ordinary share capital. So back to the point I mentioned in the previous slide, EIS shares are not able to carry a preference in the same way that an ordinary share would carry a preference. EIS shares rank what we call pari passu, or equivalent with the ordinary share capital company. But if you're an investor and you're putting money into the company, receiving these EIS shares, then as I say, you get some significant tax reliefs. So one of those tax reliefs is income tax relief of up to 30%. So that means that if you're investing in the company, your private capital, then you can get a tax relief of up to 30% of the amount. Up to 30% of the amount that you've invested from your income tax returns on your income. You're also able to benefit from capital gains tax deferral. So this means that if you've invested in a non-EIS company, so a different company, you've sold the shares in that company and you've gained a profit, then typically that amount of increase in value is subject to capital gains tax. However, if you take that increase in value that return that you receive from the sale of a non-EIS related company, then you can reinvest that into an EIS scheme and therefore defer your capital gains tax on that. You can also benefit from inheritance tax relief if the investor were to pass away. And there's a capital gains tax exemption on the disposal of the EIS shares, as long as you hold those shares for at least 3 years from the time that you invest. So it's a hugely beneficial tax relief scheme. And it's one of the ways in which companies are able to attract interest and investment from a number of private investors, in particular angel investors or smaller investors, and and get them on the cap table at an early stage. There's a reference here to SEIS. SEIS is the equivalent. There's slightly different rules that apply, but that's for smaller companies. So one of the key issues in the term sheet will be around the ability of investors, shareholders to transfer shares and the ability of the company to issue shares. So there's this concept of preemption rights. And preemption rights really gives existing shareholders the right to purchase new shares on a pro rata basis when those shares are issued by the company. And that's an anti-dilution protection for those existing shareholders. So it means that those existing shareholders are able to maintain their relative ownership percentage if the company is planning to issue shares to a third party. So typically you will see a right of preemption on new share issues in the term sheet. There's also the concept of preemption rights on the transfer of shares between shareholders or to third parties. So this is the right that if I'm an existing shareholder of the company and another shareholder wants to transfer their shares to a third party, then I have a preemption right. So I have a right of first refusal effectively over transfer of those shares before they get transferred to the third party. And this allows the company and the shareholders to protect the current ownership of the company, to effectively retain control and prevent external parties from coming onto the cap table. Again, it's quite common in the context of BBCA standard agreement. There are certain exceptions to both of those rules, which are known as permitted transfers. And that would allow me, for example, to transfer my shares to a family member or to transfer my shares into trust or into a tax-related investment scheme that is for my benefit. So drag-along rights and tag-along rights. So drag-along rights are the concept that majority shareholders can compel minority shareholders to sell their shares under certain circumstances. So you'll see on the slide we put the percentage of 50% in brackets. That's because that number is negotiable. And it's negotiable depending on the layout of the cap table, the layout of the investors on the cap table. Really, that you could see any number in there. It's typically around 50-60%, but you could see any number in there. The way that the drag rights work is that if there are holders of 50% of the shares and they want to sell to a third party, then that third party will likely say, actually, I don't want 50% of the company, I want 100% of the company. What guarantee can you give me that everyone will sign up to this transfer agreement and I can get 100% of the shares? And the drag-along provision facilitates that. So the drag-along provision means that only holders of 50% of the shares need to sign up to that transaction agreement, and then a notice can be issued to the holders of the remaining 50% of the shares, and they'll be compelled to sell their shares on the same terms and with the same pricing to the buyer of the company. So drag-along can be a bit of a double-edged sword sometimes, because if you're a minority shareholder, then you could find yourself in a position where you're being obliged to sell your shares. And back to the point around the preference stack, there are certain circumstances where certain more highly ranked shares, so A ordinary shares, preference shares, will get paid out, and ordinary shares will not get paid out. So in certain circumstances, it could be detrimental for the minority shareholder. But on the flip side, it's also a benefit for typically the majority shareholder, because it allows the sale of the company in circumstances where otherwise a sale process might be blocked by a minority or a significant minority of the shareholders. The point here being is that a drag is to be expected as part of any investment round. It's really, the only question really is where you set the percentage trigger in respect to that drag. Tag-along is a similar concept. It tends to be less controversial and less commonly used in practice. But tag-along is the concept that 50% of the shareholders of the company are selling their shares to a third party. That 50% hasn't dragged the remainder, and the third party hasn't said that it necessarily wants the remainder. But as the remaining shareholders, you might say, well, we don't want to be 50% shareholders along with this new third party. We want to go along for the ride. We want to sell our shares along with the other 50%. So tag along is this concept that as the minority group of shareholders, you can issue a notice to the selling shareholders and say, look, your sale of your shares needs to be conditional on this buyer acquiring everyone, not just your 50%. So it provides minority protections to the minority shareholders. As I say, though, it's less commonly utilized in practice because typically buyers do want to acquire 100% of the company. So moving on to the board. So as you'll be familiar, the board is comprised of the directors of the company. Initially, that's the founder director or the founder directors of the company. As you go through a fundraising round, the investor or the key investor will expect to put an investor director on the board. If your round is comprised of multiple investors, then typically one investor will take the lead and have the right to appoint an investor director. So it's not a right that would be given to every single investor individually, but it's a right that would be given to the lead investor. And then board meetings would typically be subject to the founder director or directors and the investor director being present. Now, there are certain protections that we typically include. So what happens if people don't turn up to meetings and they try to scupper the business of the company? So there are protections that can be put in place for those purposes. But for the most part, business of the company only takes place if the founder directors and the investor directors are present. In terms of decision making, this is connected with the theme of control. So this is the investor director approvals and the investor majority approvals. So investors might not control the board, and typically at the early stage, they wouldn't control the board. So let's say the board is comprised of 3 founder directors and 1 investor director. So clearly the founder directors in that scenario can outvote the investor director 3-1 and pass most decisions of the board by themselves. However, there's certain points where the investor will want protection. At investor director level, that typically covers things like bonuses in respect to employees or hiring personnel, if those personnel are paid more than a certain salary. It might cover things like approval of the annual budget, or instigating or defending litigation. So there are certain key material decisions that the company might make in its course of business, and the investor director will say, notwithstanding that you can outvote me 3-1, I need to be on board with those decisions. So effectively, I have a veto right over those decisions. Again, that's a very customary position. The only real negotiation is around, well, what are the provisions where you have the veto? But even that list is fairly standardized now. There's some negotiation on certain points, but it's a fairly common list that people sign up to. Investor majority approval is a very similar concept. So this is saying that as an investor group, as a group of investor shareholders, we should have a veto right over certain key decisions. Typically, those are decisions that go to the economics of the investment itself. So it might be in relation to the company issuing shares to a third party, which would have a dilutive effect on existing investors. It may relate to the company changing its constitution, which might change the rights which are attached to the shares of the investors. So there are a number of matters where protection at board level isn't sufficient. Investors would expect protection at shareholder level. There is a bit of a kind of legal nuance point here, which is as a director of the company, you technically owe duties to the company and shareholders as a whole. So even if you've been appointed as an investor director, you owe your duties to the company and shareholders as a whole. So your loyalties lie there, not technically with the investor itself. So there are certain decisions where an investor director can't just look to the interests of its appointee investor. It needs to consider the interests of the company as a whole. At shareholder level, that doesn't apply. So shareholders can be selfish. Shareholders can act in their own individual interest. And that's why there are certain decisions which are not just subject to an investor director veto, but they're subject to investor shareholder consent separately. Investor information rights. So again, these are fairly customary. These give the investors or certain investors typically financial information rights over the company. So it's a right to receive annual accounts, typically a quarterly management update. So quarterly management accounts, KPI indicators. Are we in line with budget? Are we overspending budget at the moment? What are the prospects for the company? What are the prospects look like in the next 12 months? So these information rights are not usually shared with all investors, but typically go to the lead investors or the key investors, or investors holding a minimum percentage of the share capital in the company. It can be somewhat burdensome as a management team to comply with some of these information rights, but it's all part and parcel of going through an investment round and putting procedures and policies in place, which are required as the company grows and becomes more and more mature. So these investment rights, there can be a bit of flexibility at the very early stage of a company's life cycle. So if you're looking at a very early investment or financing round, but as the company goes through additional financing rounds, that leeway, that slack will disappear, and there'll be an expectation that the company is able to comply with these investment rights obligations. Term sheets, founder vesting and levers. So Richard already touched on the concept of EMI options and options available to the management team. This is a similar concept in relation to options which are issued to founders. So founder options are typically subject to something called a 4-year vest with a 1-year cliff. What that means is that as a founder, let's say you're entitled to 100,000 options, and you say that you're entitled to that 100,000 options over a 4-year period. The 1-year cliff is the initial period from the point of grant of those options until the 1-year anniversary of that grant. And from that period of 0 to 12 months, you have no entitlement to any of the options. The options themselves aren't exercisable, they don't vest. When you get to that 12-month period, though, 25% of those options to which you're entitled will vest. So you'll get 25,000 at that point. From that 12-month point all the way through to the 48-month point, the remainder of those options, the remaining 75,000 of those options, will vest typically on a monthly basis. So this is a concept of a 4-year vesting cycle with a 1-year cliff. And that's a very typical concept within a venture capital investment round.
Paul, so just to jump in very, very quickly, just to clarify, I guess we typically see the same vesting regime both in the option scheme for the employees, and then for the founders, it can apply to their existing shares that they already hold in the company, which can sometimes leave founders thinking, wait, what? It's my company. Why am I on a vesting? Why could I lose some of my shares in the company? Which is a bit of a psychological jump sometimes, but the rationale is that the investor is partly investing in you as an individual, and if you just leave the company after they've invested, that can completely undermine the value of their investment. So they want to make sure that you're around and committed to driving the business. So you do see the same 4-year cliff, but for employees, it's typically in the option scheme and documents, whereas for founders, it's often in the articles, right?
Yeah, definitely, and that actually plays into this good lever, bad lever concept. So the rationale for all of this, as Richard says, is investors wanting the founding team or the founder to stay within the business. So typically, they'll say that if you leave the business under certain circumstances, then you'll be categorized as a bad lever, so you'll lose your entitlement. If you leave the business, though, in other more favourable circumstances, and we'll come on to whether they're actually favourable, but other circumstances, then the investor will say, look, you may have left the business for circumstances which are outside of your control, and because of that, I understand, and I don't expect you to lose everything as a result of that. So if we go into the next slide, we've got some examples of what constitute a good leaver and a bad leaver. So under the BVCA model standard, a bad leaver is someone who resigns or leaves as a result of gross misconduct or gross negligence, or where they're summarily dismissed under their employment contract. So really, I mean, what that boils down to is that you've done something bad, very bad, and you've been dismissed, or you've done something bad and you've jumped out the window. You know, you've resigned before they were able to sack you. So those are the kind of key points where you're categorized as a bad leaver, and you would effectively lose your entitlement. A good leaver is if you leave in any other circumstances. So there may be circumstances where a founder needs to leave a business for personal reasons, or if they become ill, or if they pass away. So in those types of circumstances, you'd be categorized as a good leaver. The board also retains the discretion to categorize you as a good leaver. So if you're leaving on good terms and the investor is comfortable with that, then you typically be categorized as a good leaver as well. Okay, so moving on to the subscription agreements. So this is quite an important point, actually, in terms of the economics of the investment round and where risk lies in terms of the investment. So one of the big areas of focus for any investor will be around the diligence process. So they want to know the commercial, financial, tax, and legal status of the business that they're considering making the investment in. That typically plays out through the due diligence exercise, which can be fairly time intensive and potentially costly from in terms of it being a distraction to the company management team. It's also not uncommon for companies to find problems within the business as part of the diligence exercise. So typically, a lot of the earlier stage companies that we work with, they go from 0 to 100 over a very short period of time. So they've not had the kind of mental space or time to put proper policies and procedures in place. There are often things that are skimmed over, and they're problems for tomorrow. But unfortunately, when a fundraising comes around, tomorrow becomes today, and so these problems need to be dealt with. So one of the things that we do is work with companies to make sure that they're fit for purpose, that they're workable for the fundraising round. We fix the issues with them, and we do that on a cost-effective basis so that it doesn't hold up the investment round or worse than that. But due diligence is all well and good, but as an investor, I say, well, you've provided me with all of this information about the company, and I'd love to take you at your word, but on what basis can I rely on this information? And that's really where we get into warranties within the subscription agreement. So as part of the subscription agreement, investors will require the company and potentially the founders to give warranties about the business. So for example, they'll be asked to warrant that the company has no ongoing or pending litigation or litigation threatened against it. They'll be asked to warrant that the company owns the IP that they've developed for use within the game, as Richard mentioned earlier. They might be asked to warrant that they haven't used AI in the creation of the IP. So all of these are kind of blanket statements that the warrantors, typically the company and sometimes the founders, are required to give. The way that the information is fleshed out is that those statements are given, but against those warranties, disclosures need to be made. So there might be a warranty that says, I haven't used AI in the creation of any IP, but against that warranty, you might need to disclose, well, actually, I have used AI, and here's the limited purpose for which I've used AI, and here's the policy which has applied in respect to the use of the AI. So you give the blanket statement, but you disclose against it. And the ultimate backstop, the reason that the investors can rely on those warranties is because someone at the end of the day is putting some skin in the game and is financially accountable for each of those warranties. So as I say, the company will typically give those warranties, but that only provides the investor with so much comfort because the investor is putting money into the company. So on a best case scenario, they can get that money back out by making a claim against the company for breach of warranty. But the reason that company's raising money is so that they can spend the money because it wants to expand its business and invest. So there's a more likely than not scenario that the company won't have the cash to pay back the investor on a breach of warranty. And that's where we get into a discussion around the founders giving warranties themselves to the company. So this is actually a point which is negotiable. It's not always the case that founders will give the warranties, but if founders are required to give the warranties as a cost of getting the deal over the line, then typically we'd look to cap their liability at 1 times gross salary. Again, there can be some flexibility on that, but one times gross salary tends to be the place that most people end up. Founders are required to give the warranties. And then finally, just touching on some of the other actions which investors will expect within the wider context of the investment being made. So firstly, they'll want to make sure that any IP generated by the founders is owned by the business, as Richard said. So that goes to the IP assignment, which is sometimes in the employment agreement or is sometimes separate. Secondly, if a founder does leave, then in addition to the points around vesting, the investor will want some comfort that the founder won't go into competition with the company, or the founder won't start to solicit the employees of the company or start to solicit the customers or suppliers of the company. So they'll expect the founders to give those protections on day one at the point the investment is made. And then thirdly, the investor will want the founders to be signed up to customary employment terms that the investor is comfortable with. So Richard mentioned about the employment contracts being in place. So if you have no employment contract in place, you should expect investors to require you to put an employment contract in place. If you do already have an employment contract in place, then great, but expect the investor to review that. And if there are terms in that the investor is not happy with, then expect them to ask you to amend it or to put a new contract in place that they will be happy with. So that is a kind of whistle-stop tour of the key points which are typically found in term sheets that typically come up in the context of a negotiation on an investment round. There's obviously a lot more nuance that we haven't covered on this call, but we try to cover off the key drivers of value, the key things that you should think about ahead of going into an investment round. I think with that, we'll maybe open the floor to questions.
Thank you so much, Richard and Paul. That was really, really interesting. There's an awful lot to sort of take in there. I think it might be helpful for our audience's perspective just to have a handle from your perspective on, I suppose, some of the trends that you've seen in terms of those sticking points. You know, is there something that sort of frequently comes up for you as being a bit of an issue? Is just, yeah, I'd be interested to hear your thoughts on that.
Do you want to go first, Richard, or?
Yeah, where do you start? I guess there's some of these points are very much open for negotiation, right? There's often a bum fight around board composition, especially if you've got, as Paul very correctly said, like you're not giving board seats to everyone. They typically go to lead investors. Of course, you do get situations where you have multiple investors in a round who are putting in a similar check size, and they all like to call themselves co-leads. And then there's a question over who gets the board seat, who gets an observer seat, what the overall board composition is. I've seen a lot of fights around this. The vesting arrangements we were talking about as well. So we see pressure there, particularly where you may have gone through a vesting.
I think what Richard was saying was we do often see pressure around vesting. So there is some negotiation around the period of vesting, and occasionally decreasingly nowadays, because there's been a convergence on what constitutes good leaver and bad leaver, but there is still some discussion around whether you would be whether you would be a good leaver or bad leaver in certain circumstances. And the third category where there's usually a lot of discussion is around whether there's an option pool to incentivize management and other employees within the company, because the option pool is dilutive to investors as a whole, so it potentially changes the economics of the transaction. So investors are quite keen to button down what the option pool looks like, what its size is, and how that's going to be deployed.
Wonderful. Well, thank you so much, Paul, and thank you as well to Richard. Managed to last most of the session before dropping off. It's not a problem though. You covered that very, very well. So thank you for that. Unless there's any more questions, I think we should draw this session to a close. Thank you so much for joining us, everyone, and thank you as well, Paul. And do pass on everyone's thanks to Richard as well.
I will.
All right.
Okay. Thanks, everyone. Thank you.